Right, good morning everybody. Counting down the days now till Christmas. Yeah, some of us already had too many mince pies, but there you go. Could we start, please, this Countryside and Rights of Way panel of the 13th of December, Friday the 13th, sadly, with, first of all, apologies, please.
Thank you, Chair. Yes, apologies received from Councillor Abrahams, Councillor Snape, Councillor Waring and Councillor Williams. Thank you.
Okay, and thank you for the members that have turned up this morning. I realised that we had full council yesterday and it is Christmas, so at least we've got three members, which is well quorate, as it were. Have we any declarations of interest on the items on the agenda? No. And the minutes of the 15th of November in front of you? Are you happy with them, Caroline? Yes. Thank you. Just sign them. There you go. Thank you. And we'll move on, please, to S53 delegated decisions. We've got a report, I understand.
There are no delegated decisions from the last panel, Chair.
Got that wrong then, didn't I? Okay. Number 5, update on definitive map modification order. This is the backlog. Do you want to take that one then?
Thank you, Chair, members. This report is to update the panel on the current position in respect of the backlog of undetermined definitive map modification orders and directions from the Secretary of State, together with an update in respect of the later stages in the process following determination. As you can see from the report, the county still has a significant backlog of undetermined applications, which is currently 266, including 31 on which the council has been directed by the Secretary of State to determine within a specific time frame. The council also has a backlog of 95 determined applications for which a modification order needs to be made and published for each of those applications. Since 2017, the Council has received 160 new applications and has been directed by the Secretary of State in respect of 170 applications, some of those being existing applications. It has determined 140 applications. These figures are set out in the table on page 2 of the report, which shows a breakdown of those figures for each year since 2017. What the figures show is that the county has received a considerable number of new applications since 2017 and shows a trend from 2020 to 2022, which saw more new applications than determinations. The more recent figures from 2023 and 2024 show a reduced number of new applications with more determinations than new applications. However, the backlog still remains high, but is beginning now to decrease. The number of directions received was very high for the period between 2017 and 2020, although this number has reduced over the last 4 years. During the last 4 years, the county has determined more applications than directions received, and so the number of directed applications continues to reduce, but there is still a backlog of directed applications still to be determined, which currently stands at 31. Also set out in the table below are the figures for each year in respect of the making of definitive map modification orders resulting from determinations, together with the number of appeals against refusal to make an order and the number of contested orders, many of which are yet to be concluded and some of which may result in public inquiries. And so there is still a large backlog of post-determination work outstanding. The report, which was presented to the panel on the 16th of June 2023, identified 3 measures which may assist in reducing officer time in processing definitive map modification orders. The first being the increased use of delegated powers, which are limited to those matters which are non-contentious. 3 of the applications determined this year were determined using those delegated powers. The second measure being the resolution of applications by alternative means, such as a public path order or a creation agreement where this is possible. A small number of applications may be eligible for an alternative resolution and work is ongoing in respect of those. The third measure being the introduction of digital solutions. Work is still going on in respect of this, and I will keep you updated on that issue as and when there is anything to update. Thank you, Chair.
Thank you for that. Quite a boulder to keep pushing up the hill. Just a quick one for me, if you don't mind. When you say that there was an increase in applications over the last 2 or 3 years, but you're now actually that's slowing down, was it COVID that caused that, or what was the causal effect?
I think it was perhaps a combination of things, Chair. I think partly it may well have been COVID that allowed perhaps a bit more time for research, so they could submit, applicants could submit more applications. But I think also it was the threat of the cut-off date coming in, which is some new provision in the Deregulation Act 2015, which means that certain applications submitted after a certain date, after that date, well, they can't submit certain types of applications after that date. So I think there was a bit of an impetus really to get as many applications researched and submitted prior to that date as they possibly could.
Yeah, and from me as chair, could you pass on to the staff that I personally realise how much work there is to be done post-application and pre-application, and thank you very much, because it's a thankless task.
Thank you, Chair. I will do that.
David?
Yeah, Chairman, can I just, not directly relating to this, but someone mentioned to me yesterday that we'd got an appeal against one of our decisions coming up at the end of January. I'm not aware that's been reported to this committee, that an appeal against one of our decisions. What's the current situation?
Yeah, there is a right of appeal against all of the decisions that the panel makes. So if the panel decides to refuse an application, then the applicant has the right of appeal to the Planning Inspectorate or to the Secretary of State for that, against that. We don't generally tend to report those because it isn't unusual to have an appeal against a refusal. It's just part of the process. The legislation allows for that, and we just have to work through that. They don't always allow the appeals. It's determined by the Planning Inspectorate ultimately. So we are asked to submit our comments on the appeal. We do that. The applicant also submits what they want to submit and any further evidence. That's then all sent to an inspector who determines the appeal on behalf of the Secretary of State. So sometimes they will refuse the appeal, so there's no further work for us to do. Sometimes they will allow the appeal, and if they do that, then they will the Planning Inspectorate will direct us to make a modification order within a specified timescale. So if we do that, we sort of just follow the process at that point. Often that can be contested as well, so it then may go back to the Planning Inspectorate. It is quite a lengthy process and very involved, unfortunately, but there is that right of appeal at every stage.
Chairman, I'm aware of that. It was only said to me by a member yesterday at full council that there was an actual physical appeal hearing at the end of next month. And I thought that was something slightly more than what you're saying to at the moment. Are we aware of an actual appeal, or has somebody just got it wrong? I'm not reckoning that most councillors get things right every time.
It's not anything that I'm aware of. We will be having some public... We are aware that we've probably... Well, we have got at least one public inquiry coming up later in the year. We haven't had a date for that yet. We may have another 1 or 2 public inquiries this year as well, but I'm not aware of anything that's happening in January in relation to Section 53 matters.
I think, David, you did mention it to me with regard to quarries. I think you might find that if there is an appeal, it's with the main planning committee. Okay, thank you. Right, thank you for the report, and we'll move on, please, to item number 6, which is the Wildlife and Countryside Act 1981, application for the upgrade of public footpath 11, Wetton, to a public bridleway. Thank you.
Thank you, Chair, members. This application is to upgrade public footpath 11 Wetton to a public bridleway along the line of the route at the plan attached at Appendix B. The application is supported by historical evidence. I can confirm that no comments have been received from the local member. Turning to the recommendation, that is, that a modification order should not be made to upgrade public footpath 11 Wetton to a public bridleway. The applicant submitted a plan of the Manifold Light Railway and a draft definitive map. Officers also considered the Grindon Tithe map and Ordnance Survey maps. Deposited railway plans were concerned with mapping lands for the purposes of construction of the intended line of the railway. The deposited railway plan shows the line of the route in the Grindon parish. The original application, the applicant relies on the deposited railway plan, suggesting that public footpath 11 Wetton is one continuous route of existing public bridleway 10 Grindon. Whilst the deposited railway plan does appear to show the route of the existing public footpath 11 Wetton on the opposite side of the river manifold, there are no plot numbers allocated to that section of the plan, as this falls outside the line of the route for the proposed railway, and therefore the status cannot be identified from this evidence. In any event, the route that the applicant suggests meets with the route in question is suggestive of a public footpath and does not provide any positive indication that the route was in fact a public bridleway. The deposited railway plan therefore does not support the contention that the route in question had the status of a bridleway or that it is a continuous route with any higher status than a public footpath. The National Parks and Access to the Countryside Act 1949 imposed a duty on parish and district councils to provide information on public rights-of-way in their area. The details of the routes were marked on Ordnance Survey maps, together with a record card containing the details of the survey. The applicant submitted a copy of a draft definitive map and statement, which would appear to depict the claimed route as a RUP. However, on investigation, the map which was submitted has never been listed as definitive, and these were likely shared with councils for parish meetings, and despite being labelled as definitive maps, they lack the official county seal. The draft definitive map and statement submitted, therefore, cannot accurately be confirmed as such. Without this supporting evidence and documentation containing the legal seal or the parish survey cards, this document adds little legal clarification as to the status of public footpath 11 Wetton. Officers reviewed the Grindon Tithe map. Whilst these documents are solely concerned with identifying tithable land and were not intended to establish or record public rights of way, they can be useful when identifying a location of a route. The Grindon Tithe map would appear to show a route in the Grindon parish, depicted by two parallel dashed lines in the same position as existing public bridleway 10 Grindon. This evidence supports the location of bridleway 10 Grindon, however it does not positively identify if the way was public or private, or if there was any higher status assigned to it than a footpath. Nor does it identify any nature or status of the application route in the Wetton parish. The Ordnance Survey maps provide evidence of the physical features that they show at the time of the survey, but again they do not assign status to routes. The route is shown as two parallel lines running in a north to northeasterly direction from the river manifold to Larkstone Lane. However, this could be public or private, and Ordnance Survey maps cannot be of assistance when positively identifying the status or nature of a route. Upon consultation, the applicant submitted comments in respect of the report. Officers reviewed the parish survey cards in relation to Bridleway 139 water houses following comments from the applicant. This confirmed that Bridleway 139 water houses was intended to link with Bridleway 10 Grindon. There is no suggestion or mention that Bridleway 139 water houses connects over the river via a ford with the route subject to this application. The applicant, within their statement at Addendum 1, purports that Bridleway 139 water houses connects with public footpath 11, Wetton. However, there is no evidence to positively clarify this assertion. The applicant considers that an extract from the Council's survey rights-of-way query papers for Waterhouses Parish has mistakenly recorded RUP 140 Waterhouses linking with RP 11 Wetton, suggesting that this could potentially be referring to Bridleway 139 Waterhouses linking with RUP 11 in Wetton. As indicated within Officer's response at Addendum 2 of the papers for members, this claim is speculative, and to reach this conclusion would require assumptions that are beyond what the evidence supports. As referred to within the report and previously mentioned, we cannot draw any definitive conclusions from the additional ordnance survey maps provided by the applicant, and they cannot confirm the legal status of the route. Again, the tithe maps do not provide evidence of legal status, and nor does this evidence provide any clarification or details of any part of the application route. The Ilam tithe map only highlights a route in the Waterhouses parish and offers no evidence to confirm the position, location or status of any proposed continuation to the north within the parish of Wetton. Again, the evidence relies solely on speculation in connection with the application route. The deposited railway plan was thoroughly reviewed by officers upon investigation. As explained, the plan does not include details of ownership for the ford over the river in the Waterhouses parish. It cannot be assumed that the ford was for public use simply because it was shown on the plan. Furthermore, the plan does not provide detail regarding the application route. The application is made under Section 53 3C2 of the Wildlife and Countryside Act. The burden is on the applicant to show that, on the balance of probabilities, that it is more likely than not that the definitive map and statement is incorrect, and the existing classification must remain unless and until the panel is of the view that the definitive map and statement are wrong. None of the documents provide sufficient evidence on the balance of probabilities of higher status than a public footpath. Whilst it could be purported that the route was believed to be of a higher status when recorded on the draft parish survey as a RUP, this evidence does not contain the legal seal and therefore does not add sufficient probity to the claim for a higher status of the route following the special review. The evidential documentation only refers to surrounding routes in different parishes and not the application route, and the assertion that it must have been a continuation is speculative and not legally adequate to support an upgrade, and therefore the evidence is insufficient on the balance of probabilities to establish that the route had any higher rights than that of a public footpath. Officers therefore recommend that the application is rejected and that an order should not be made to upgrade the route to a public bridleway on the definitive map and statement. Thank you. I'm happy to take any questions.
Thank you very much for the report. David?
Thank you, Chairman. Could you tell me, do we have any evidence of what the current usage is of the footpath, regardless of its legal status? I mean, is it something that's regularly used, or is it something that's been dug out of the archives by someone?
It's current listed on the definitive map as a public footpath. With regards to the usage, current usage, obviously it's permitted at the moment as a public footpath.
Carolyn?
Thank you for this report, very detailed, but to me it's obvious that the evidence given is insufficient on balance of probability to establish that the route has a higher status. So I would just like to propose I follow this as officer's recommendation, not to update it to a bridleway.
I'll second that, Chairman.
Thank you both for that. So we've got a proposed by Carolyn, seconded by David. All those in favour? So we'll go with the officer's recommendation to reject the application and not make an order to upgrade the definitive rights of way. Thank you. Thank you very much for a very long report. Item number 7, again, Wildlife and Countryside Act 1981. And this is for the application for the addition of a public bridleway, Prestwood Lane, Denston, Elliston. Have we had any response from the local member?
No.
Right, okay, thank you. Would you like to proceed?
Thank you, Chair, members. And so this application is to add a public bridleway along the line of the route on the plan attached at Appendix B, namely Prestwood Lane. The application is supported by historical evidence. I can confirm that we've had no comments from the local member. Turning to the recommendation, that is that a modification order should be made to add a byway open to all traffic along the line of the route marked A to B on the plan attached to Appendix B. Turning to the evidence, the applicant submitted a Finance Act plan, tithe map, schedule of minor roads for maintenance, ordnance survey maps and a map of footpaths and bridleways for Staffordshire County Council. The route is listed as an unclassified county road in the list of streets, which is maintained under Section 36 of the Highways Act 1980. This list records highways maintainable at public expense. While the list of street confirms public maintenance responsibility, it does not clarify the route's legal status. The 1910 Finance Act map was concerned with mapping lands for the purposes of taxation. The Finance Act map shows the line of the route excluded from any surrounding parcels of land. The fact that the claimed route is shown excluded from adjacent land holdings and is shown as an unnumbered, uncoloured route presents a strong possibility that it was considered a public highway. Tithe documents are solely concerned with identifying tithable land. Whilst tithe maps were not intended to establish or record public rights of way, they can be useful when identifying a location of a route. The Presswood tithe map shows a route running along the same line as the claimed route, depicted separate from the adjacent land and coloured sienna, consistent with other connecting roads in the local area. The Yates's map can be useful to identify the physical presence of a route, but cannot determine its status or legal rights. The route appears on the Ordnance Survey map as solid parallel lines annotated as Prestwood Lane. While the map shows the route's physical existence, they cannot clarify status. They do, however, provide evidence of the physical existence of the features that they show on the ground at the time. The list of roads dated 1929 for the borough of East Staffordshire is considered conclusive proof of the existence and public maintenance of the route. The route is already being publicly maintained by the Highway Authority. The nature of this route is recorded as an unclassified county road to which no legal status is designated. The question, therefore, relates to the nature of the public rights which exist along Prestwood Lane, namely whether it carries footpath, bridleway, or higher rights such as restricted byway or byway open to all traffic. Whilst each individual piece of evidence on its own does not conclusively identify the status or nature of the route in question, when considered in totality, the evidence indicates that Prestwood Lane was a well-known local public route which carried higher rights than that of a public footpath or bridleway. The historical evidence consistently depicts the route for a period of over 200 years, linking with other public vehicular highways. Therefore, the evidence strongly indicates that Prestwood Lane is a significant public route with higher rights exceeding those of a footpath, bridleway or restricted byway. If the evidence suggests higher rights, such as vehicular rights, exist, the Natural Environment and Rural Communities Act 2006 must be evaluated. Under Section 67(2)(b) of this Act, motorised vehicle rights must not be extinguished if the route was recorded on the Section 36 list of streets, but not on the definitive map and statement immediately before the Act's commencement. In this instance, the route qualifies for this exemption, preserving vehicular rights. This raises the possibility of designating the route as a byway open to all traffic, defined under Section 66(1) of the Wildlife and Countryside Act 1981 as a highway over which the public have a right of way for vehicular and all other kinds of traffic, but which is primarily used by the public as a footpath or bridleway. Officers believe there is sufficient evidence to allege that public vehicular rights subsist over the route. Therefore, motorised public vehicular rights remain intact. Following circulation of the report, comments were received from the applicant and a local landowner. The applicant expressed concerns that the addition of a byway open to all traffic may be unsuitable for horse riders and cyclists. In light of these concerns, the applicant has asked that the Countryside's Rights of Way panel consider recommending that the route is added as a restricted byway. Officers confirmed that whilst it is not our intention to belittle any legitimate concerns that are raised in connection with the safety and suitability, these matters cannot be taken into consideration when determining whether a public right-of-way exists based on historical evidence. The evidence is suggestive of higher rights over the application route, and this particular route will be exempt from the NERC Act due to its inclusion on the 36 list, and therefore byway open to all traffic will be the appropriate designation. A local landowner emailed to confirm that they have no objection to the addition as long as it does not stop the lane being used as it is now for general traffic. The lane is used for farming purposes, the water board, a campsite and allotments are located along the route, and a local business requires access to their fields. There is a two-stage test, one of which must be satisfied before a modification order can be made. All the evidence must be evaluated and weighed, and a conclusion reached whether the alleged route subsists on the balance of probabilities or is reasonably alleged to subsist. For the first test to be satisfied, it will be necessary to show that on the balance of probabilities, the right-of-way does exist. For the second test to be satisfied, the question is whether a reasonable person could reasonably allege a right-of-way exists, having considered all the relevant evidence. In conclusion, although the application was made for the addition of a public bridleway, having regard to the totality of the evidence, officers consider that there is sufficient evidence that higher public rights were in existence over the route and that the most appropriate status for the route is a byway open to all traffic. Therefore, officers considered that the evidence is sufficiently compelling to reasonably allege that a byway open to all traffic exists over the route marked A to B on the map attached at Appendix B, and that a modification order should be made to add the route as such to the definitive mapping statement for the Borough of East Staffordshire. The width of the route should be to 3 metres throughout its length. Thank you. I'm happy to take any questions.
Could I just clarify, looking at the recommended option, it says to accept the application based on the reasons contained in the report, to add marked A to B on the definitive map of the public rights of way in the Borough of East Staffordshire. So it doesn't actually say anything about, or to my mind, that it's not just because the original application was for a bridleway, wasn't it? So this in front of us doesn't actually say it's more than a bridleway, or am I wrong in thinking that?
I think that the recommended option explains that it's the reasons contained within the report, and at 93 it says that we should add a byway open to all traffic. So I think that that's what the recommended option is referring to. So
it's clear enough on the recommended option, you feel as an officer, that because I'm concerned that we say, as some of the landowners and allotment owners have said, that if we make it a bridleway, that someone will say it's a bridleway, you're not allowed to drive down here. I'd just like it a little bit clearer than that. Could you add a few words to that recommendation?
So the historical evidence that's been discovered and reviewed by officers considered that there are public vehicular rights that were in existence along the route at the for a period of time. So that's why the byway open to all traffic has been recommended rather than a public bridleway. Officers consider that the evidence suggests higher rights than that of a public bridleway.
I'm still not totally happy with the clarity, because there it just says to add the route A to B to the definitive map and statement of public rights of way in the Borough of East Staffordshire. It doesn't say that bit about higher rights. Could we add that to it?
Yes, I can add that to the recommendation within the minutes to confirm that it's for a byway open to all traffic. I think that that's merely referring to the the paragraph above where it says that there's a byway open to all traffic, but we can add that into the recommendation if that would satisfy members.
Would be a lot happy with that, but what do members think? All those in favour? Thank you. To be picky, but that's what we're here for. Carolyn.
Thank you. Now we've added that in. So I look through the, and I do agree with you, a boat order is better than making it just for horses, so a bridle way. When I looked through all these documents and I came to the same decision as you, that a boat order is a must here because it's already used for cars. What I didn't understand is why horses weren't already used in it. So I didn't, and to me that's a lesser to make it a bridle way than a boat order, and so maybe that's just my inexperience. Could you just explain that a little bit to me of why someone would apply for a bridle way when it's obvious that it's already used by traffic? Sorry.
I do think that it's mainly for the reasons of a legal status, and that's what they're trying to ascertain. When it's an unclassified county road or a green lane, there isn't any legal status designated to the route. And therefore, the applicant was seeking for a legal designation along the route by applying for a bridle way, but officers have discovered and considered that vehicular rights exist.
Then, well done again for doing your job right and going over and above what the public have seen. I'd again like to accept this on officer's recommendation, subject to the changes that was mentioned earlier on. We hadn't recommended it. We'd recommended the changes, that was all. Your amendment, that's all.
For your recommendation, and we're all happy with that. Thank you very much, and thank you again for a very informative presentation. Could we move please to item number 8, Wildlife and Countryside Act 1981, and that's the applications of an upgrade of part of public footpath 27 Checkley Parish to a restricted byway, and the remainder of the public footpath 22 Checkley Parish to a public bridleway. Would you like to take that one, please? Thank you.
Oh, good morning, Chair and members. Thank you. This is an application made under Section 53 of the Wildlife and Countryside Act 1981 to upgrade public footpath 27 Checkley to that of a bridleway. The application was made in 2019 by Felicity Edmiston on behalf of the Staffordshire Moorlands Bridleway Group. Her evidence included the Checkley Enclosure Award, Checkley Tithe Award, Checkley, Crichton and Stramshall Parish Map of 1837 and Checkley Parish Minutes of 1898. The applicant also included the Checkley Parish Survey Card and Map, a letter dated 12th of August 1954, and a copy of a page with the heading Survey of Rights of Way dated 7th of September 1954, both of which were associated with the first draft map and statement. Finally, she included Ordnance Survey 25-inch maps dated 1881, sheets 25-8 and 25-4, an Ordnance Survey 1-inch map dated 1897, and site photos. Your officers discovered 2 Ordnance Survey maps dated 1889 and 1930 and Bartholomew's map of 1924. The enclosure award consists of a plan and award which states the route to be a public carriage road 30 feet in width. The plan shows the route leading off the Hollington Road and extending as far as the old enclosures. The Checkley Tithe Award and parish map, produced 4 years apart, show identical features to each other. They also show the enclosed route identified on the enclosure plan. Between points B and C on the plan attached as Appendix B, both maps show markings which are suggestive of either a route along a field edge or alternatively that the fields are enclosed initially to the west and then on the easterly boundaries as the route continues southwards. The route opens out slightly at the southerly end of plots 1534 and 1509 on the tithe map. These field parcels are the southernmost fields owned by John Burton Phillips, owner of Broadgate Hall. The hall is situated just to the west of these fields. The parish minutes of 1898 state the route to be a cart road from back of Edward Morley's and coming out into 24 near Overton Farm. The applicant has also provided details which can be found in the addendum stating that Mr. Morley lived just off the Hollington Road around this date. This addendum evidence confirms that a cart road ran from the Hollington Road to Bridleway 24, which is the claimed route. Whilst these minutes should have been signed off by the Surveyor of Highways, and indeed may have been, although this is unclear, this is good evidence of a cart road for the length of the route. Whilst it is likely that the parish minutes included only public routes, it is, however, possible that private routes would also be included. The survey cards from 1951 make reference to the route originally being marked as a bridle road, although this was subsequently reconsidered within the council and downgraded some 3 years later. Ordnance survey plans were provided which shows markings of a physical way along the claimed route for the years 1881 and 1897. From point B at Appendix B, the 1881 plan shows 2 sets of broken lines leading southwards across part of the claimed way. These tracks then become a single route. At point C, the claimed route becomes enclosed as far as point D. The map of 1897 shows similar markings to that of the 1881 map, but from point B to C there appears to be only a single track. This plan of 1897 does not appear to be as sophisticated as the plan of 1881. The applicant has also provided photographs. Whilst these are helpful showing Stonegate pillars, stiles and sections of the route, there is no evidence of when these physical features were put in place. An initial consultation was undertaken. 5 landowner evidence forms were received. Landowner 1 stated that the section over their land had never been a public right-of-way, but was used as a gentleman's agreement for the Heath House estate to be used as an access. The landowner, however, did not send in any evidence to support this. They consider it a public footpath with stiles and a wicket gate along its route. Landowner 2 stated that the family had owned land over which the claimed route ran since 1939. The landowner has made changes to a hedge and ditch which may have been along the claimed route, although this is unclear. He has also stated that there were gates along the route, although these were never opened. They fell into disrepair and were replaced by posts and rails to prevent stock straying. He states that a gate between his land and the neighbours was for the movement of stock and goods between the farms. Landowner 3 has provided evidence. He lives in one of the properties along the Hollington Road and advised that his interest in the land is to access a septic tank and for off-road parking. He also stated that in the 1950s the council used the lane for lorries to empty septic tanks, fill LPG tanks, and a neighbour used the lane for off-road parking. The owner stated that the way used to be a way for a horse and dray carrying timber from Great Gate to Fold Lane for the owners of Teen Hall Mills. The landowner, however, has not provided any evidence regarding this. Landowner 4 has provided an evidence form together with a covering letter in which they object to the claimed upgrade. They were concerned about future access and safety and maintenance of the lane. As a landowner, they also raise practical farming and animal husbandry concerns. Landowner 5 has also provided a covering letter and an evidence form. In the covering letter, the landowner expressed concerns about access to properties, the dangerous road junction, potential degeneration of the footpath and concerns for the farmers. They explain that their family has owned land over which the claimed route runs since 1920 and have always known it as a public footpath. A previous councillor for the area contacted officers on behalf of one of the landowners and reiterated concerns from a farming point of view. She also had her own concerns as to the safety of the claimed upgrade. As the panel are aware, such considerations cannot be taken into account when making their decision. The report was completed and sent out for further consideration. The further evidence which was provided and responded to can be found within the addendum. The applicant provided comprehensive further evidence, which has included comment on individual paragraphs within the report, in addition to further maps and plans. Much of this additional evidence does indicate that sections of narrow enclosed lanes exist along the route, which is indicative of higher rights than a footpath. A sixth landowner has provided evidence which shows a plan of a section of route leading off the Hollington Road, similar to that shown in the enclosure plan. It doesn't, however, explain either the status or whether the rights are public or private. The previous councillor for the area contacted officers again. She was concerned about the costs of maintaining the route and the damage to habitats. The current local member, Councillor Mark DeVille, contacted the county solicitor and queried the necessity of the bridleway, stating that there is another bridleway in close proximity linking Fold Lane and the Hollington Main Road. The county solicitor responded on behalf of officers, advising that the council has a duty to keep the definitive map and statement under continuous review, and that applications may be presented under the Wildlife and Countryside Act 1981 by any member of the public who believe the definitive map and statement to be incorrect. In conclusion, there is evidence of the public carriageway between points A to B on the plan at Appendix B. From points B to D, the parish minutes and survey cards do suggest the possibility of a cart road or bridleway rights, especially around the start of the 20th to mid-20th century. Officers, however, do not think there is sufficient evidence to tip the scales on the balance of probabilities. Officers also have reservations as to whether the evidence shows conclusively a public route for bridleway and or carriageway rights over the past 200 years. With this application, there is one legal test which must be satisfied before a modification order can be made, the test being whether on the balance of probabilities the higher rights subsist. It is your officer's recommendation that the application for the upgrade between points A to B passes the balance of probabilities test under section 53(3)(c)(2) of the Wildlife Countryside Act, but that the evidence between points B to D is insufficient to pass the test on the balance of probabilities. I'm happy to take any questions.
Thank you very much. Carolyn?
I only see this as a public right-of-way. I'm missing the bit of the A to B upgrading for horses, a carriageway for horses. Could you point me in the right direction of how you got to A to B to upgrade, please? Sorry.
No, that's fine. A to B was shown on the enclosure map and award. It's explained in the enclosure map and award, and that is very weighty evidence regarding the route being in existence and being a legal entity. And therefore that was good, strong evidence to show that X section of the route. Furthermore, a lot of the supporting evidence also confirmed what the enclosure award had actually said and the map. So that's why that section was considered very strong evidence. Unfortunately, the rest of the route did not have the enclosure award and plan, and therefore the weight of the evidence was less. And that's why I came to that conclusion.
Thank you, I've just seen it now, sorry. So A to B to be the bridleway, the rest just to say as public footpaths.
A to B to be a restricted byway. The evidence suggests a restricted byway. They did apply for a bridleway, but A to B, the evidence suggests it's actually got even higher rights.
That makes more sense now. Sorry, I wasn't quite with this one. I was thinking that was going to be the bridleway. Now I understand. I'm sorry. No. It's getting too close to Christmas, like you said. Absolutely agree now with the officers. I was going to fight this one. I'm now not. Sorry.
No. I think we all value the input. Thank you for that. David, and then I just want a quick word.
Chairman, it's unusual, I think, for us to have a report where we've got some parts we're supporting and some parts we're not supporting. And I just wondered whether we needed to take those as 4 separate items, in which case, I mean, I would be happy to propose the acceptance of the report and take them either as 1 or as 4 separate items.
I think the reports, when we approve the officer's recommendations, we actually do that by its very nature. Just before we do actually ask for a vote, what we're saying is A to B is tell me, A to B is a...
Restricted byway.
Yeah, so vehicles can go on that one.
They can, yes.
Yeah, okay.
Yeah, but not mechanically propelled vehicles.
Right,
Not
okay.
yes.
Okay, so B to D, what status will that have?
We don't consider that it should be upgraded from the current footpath because we can't see evidence of a bridleway. So, so that
Okay.
section.
So, and my final question is, if a person on a horse or a bike gets to point B, what do they do then?
Unfortunately, they have to turn around. They can't continue. It is in effect a dead end.
Yes,
Yes.
that was what I thought. So just to be clear what we're voting on. But we are, obviously, as David just said, voting on the evidence you've put in front of us. Are you happy that that evidence is challengeable?
The applicant can always challenge the decision, yes,
Yeah.
if she's not happy with it. And so, depending on however you, whether you go with the recommendation or not, it's...
And the point that David made, and if we agree to follow your recommendations, that will effectively take on those points A to B and B to D.
If you follow our recommendations, the applicant can challenge the fact that B to D has not been upgraded. And so they can make that challenge if they wish to do so, unless they're happy with just points A to B.
Okay, thank you. Therefore, I'm going to ask for someone to recommend it. Carolyn?
Yeah.
Seconded by David,
Oh.
agreed by all of us. Is that correct? Thank you very much.
Thank you. Thank you, Chair.
And thank you for quite a complicated report. Thank you. I do believe that there's no other items on the agenda. So can I do the important thing and wish you all and your families a happy Christmas, and pass over to David for the final thoughts.
I was only going to comment, Chairman, that as a committee we look at extremely complicated reports, as complicated as I see anywhere within the council. And so I do appreciate that as far as the officers are concerned. But I would also, on the other hand, say that they're complex reports, that we do consider them very thoroughly. And because we don't end up with a great long debate on them, that's not something that shows that we haven't read them and inwardly digested them. And I think, reiterating what you said, Chairman, earlier on, that we do very much appreciate the depth and appreciate the reports that we receive as a committee.
Thank you, Chair, members.
Happy Christmas to everyone. Thank you.